Hi friends. So I think you are all preparing for November section examination. So let me help you with your last minute revision. So I cannot tell it's an important question, but it's a mock test or revision test paper. So let me explain you how to get a good mark and how to approach the exam paper. So let me go through some mock test papers, and I have taken August 16 paper of ICI mock test paper, and I'm explaining you how to approach the paper. Okay. Now the first question is from the Companies Act. The company published the notice of AGM on 12th September 2015, and so it is like in the newspaper they are published on 12th September 2015 for the AGM which is going to happen on 7th October 2015. Okay, and they also posted the notice for AGM in like post they have sent on 16/9/2015, and the shareholders got the notice on one of the shareholder got the notice on 22nd September 2015. Now, since there is lot of dates mentioned here, you may get confused. So you should take the earliest day, that is like date on which it is published in the newspaper. It is on 12th September. Point number two, the company has posted on 16/9 for the shareholder per se. Now, the shareholder who received on 22/9, he claims it is very short period for him to attend the meeting, and whatever resolution happened in the meeting are invalid. Now, whether the shareholder is right in his contention. First of all, the 21 days is a guideline. It is not a hard and fast rule. Point number two, anyway, the company has published in the newspaper. So, there is every possibility that he has got the notice. See, unless otherwise the shareholder really got affected because of the shorter notice, no one can claim the notice is invalid, the resolution is invalid. So in this case, you can answer in two ways. One is accidental posting delay. So in this case may be accidental posting delay, and he cannot claim it's invalid. Point number two, unless otherwise he proved that he is affected party because of shorter notice. Okay. So because the company has done, okay, whatever the company can be able to do, they have done it. So in this case, the shareholder contention will not be accepted. And we will go to the second question. So this question is for 5 marks question, and the second question is also for 5 marks question. This is from Contract Act. So the minor took a loan from a person and failed to repay. A minor has assets worth of say 10 lakh. The lender wants to recover by attaching the assets of the minor. Okay, well, can the lender do it? See, this case is from Mohri Bibi's case law. So the lender cannot attach the assets. Now, will your answer be different if the lender has given the money for the purpose of education? Now, if it's for education, this is for the necessity of the minor. Hence, it can also means it can be recovered from the minor's property. So this is, if it's case of education, it can be attached. In case of other than education, it cannot be attached. So necessities, other than necessities. Then now we will go to Bonus Act because there is an amendment there. Definition of employee and employer. So the amendment is on definition of the employee because the employee includes skilled, unskilled, semi-skilled, everyone who earns a wages not exceeding 21,000 rupees. So it is now 21,000 rupees. So that is the major definition change. Now employer. So in employer in industry, that is a factory, and other than factory there are two types. So a factory means an occupier, okay, owner, or a person who termed as manager of the factory, or the legal representative of the owner or occupier of the factory. And other establishment, the person who designated as manager or managing director and who has ultimate control of the company's okay thing. So this is the definition of employer. So this they have asked for 8 marks. Then we will go to negotiable instrument act question. See, Mr. A drawn a check which is a bearer check, but he has crossed it by way of non-negotiable. The word non-negotiable has been made. So the name of the person payee has not been mentioned, but he has mentioned non-negotiable. Then subsequently he lost the check. Somebody has stolen the check, and Mr. B got in good faith. okay, from Mr. C. Mr. B has paid a value to C to get this check. Now, tell me that whether Mr. B can claim the amount from, sorry, whether Mr. A can claim the amount from Mr. B. Now, we should know what is the meaning of non-negotiable and how it will affect. First of all, we should know what is a holder in due course. The holder in due course is a person who got an instrument in good faith for a payment of value. But if the word non-negotiable instrument, non-negotiable if word is mentioned, then any person who getting in a good faith, even though he gets in a good faith, but the instrument is lost, it is not endorsed or transferred in a regular manner. Okay, he will not become a holder in due course. So in this case, B will not become a holder in due course. B will, because the person who cannot transfer a better title than what he is having. Now Mr. C who transferred the title to Mr. B, C himself doesn't have a better title. So B will not get the holder in due course title. So Mr. B will be affected party. Now Mr. A who lost the check can able to gain it from Mr. B. Now what is the liability on the bankers? Okay, will the bankers be liable for anything? No, the bankers will not be liable. Even the payee banker and the collecting banker will not be liable for anything. Then we'll go to the next question. This is from Companies Act. See, the company has 50 preference shareholders. Okay, they want to change the terms and conditions of the preference shares. They called a preference shareholders meeting. Mr. A, the only person attended the meeting. Okay, although he has held all the proxies, okay, that is 49 proxies he holds. Whether it is valid? No, it is not a valid. It is valid provided Mr. A has almost all the shares. 100% shares if Mr. A holds, then he can attend. 1% quorum is possible. But in this case, they are 50 shareholders. Hence, there should be at least 5. So that 5 in the case, 5, 15, 30 slab limit is there. No, that you should follow. So 1000 up to 1005, no? So this comes under 1000. Then the shareholder, next question will go. The shareholder who wants to inspect the proxy has given 5 days notice in advance, and 2 days before the meeting he want to inspect the proxy. Is it valid? See, proxy, if you want to inspect, you should give 3 days in advance, and you can inspect 24 hours before the meeting, but he has spent 48 hours, 2 days before, it is invalid. Then chairman of the meeting, while signing the minutes, has taken out certain matters which is detrimental to the interest of the company. Is it valid? Chairman has a right to take out minutes from when writing minutes. No, he can right to take out matters which is detrimental to the interest of the company. Hence, in this case, chairman is valid. Then, the articles of association of the company authorize the company to receive calls in advance. Now, as a shareholder, some shareholders paid calls in advance. Explain the right of the shareholder. Point number 1. If the articles of association authorize, you can pay calls in advance. The calls in advance will not be refunded at any time. But the calls in advance, the person who pays the calls in advance is eligible to get interest in case the articles authorize at the rate prescribed. Then, even if the company has no profit, it can be paid out of capital if the articles authorize. Then, he will stand as a creditor for the company. So, in case the company gets wind up, now he will get his advance, means like calls in advance, in preference to the shareholders. Okay, he will be like a creditor, he will be treated as a creditor. But because he is paying calls in advance, he will not get any additional voting rights. Okay, the whatever right which is given to all fully paid up, means like whatever called up shares capital, no? So same right is available to him. He will not be getting any extra voting right. Then, and even dividend right, you will not get any extra. The same right which is given to all. Next. Can the following person be appointed as debenture trustee? Now, first of all, you should know what is debenture trustee. Debenture trustee will be appointed. It's mandatory when a company issues more than 500 people. So, debenture to 500 people or more if they issuing, then they have to appoint a debenture trustee. The debenture trustee should not be any beneficiary of like shareholder. You should not be a shareholder beneficiary, or you should not be a creditor. Okay, you should not be a KMP promoter or their relatives. Now, this case, the shareholder holding the shares without benefit of interest, can he become a debenture trustee? The answer is yes, because he is not holding a beneficial interest. See, they may confuse you because he is a shareholder. So you may just think of, okay, shareholder cannot become. No, he is not holding a benefit of interest. Hence, he can become. Okay. So like trustee relationship. Okay, if a person is holding a trustee relationship, so that person can become a debenture trustee because he is not holding a benefit of interest. Next, can a creditor become a debenture trustee? No, creditor cannot become a debenture. So even 1 rupee or 2 rupee creditor also he cannot become. So here the amount is immaterial. And guarantor of the company. Now the guarantor of the company cannot become debenture trustee. Even 1 rupee or 2 rupee he cannot become a debenture trustee. Then the employee died in accident. So we are going to know PF Act. Now the employee died in accident. Who will receive the amount standing in the credit of his PF account? Okay. Who will receive? His nominee will be receiving the amount. Now, in case the employee has some debts due, okay, in his to a creditor. Now can the creditor attach the PF account? No. This is cannot be attached. This PF dues cannot be attached by any person. Next. Next we will go to the Companies Act. On March 2014, the company has taken a loan from a bank, charging their property. Okay, that is loan against a property. On May month, they realized that they have not filed the charge form. What happens? See, charge form has to be filed to ROC within 30 days from the day on which they have taken a loan. Now they have exceeded the 30 days, but there are 270 days grace period given for filing a form, okay, by paying an additional fees. So if they can able to file it within 270 days, there is no penalty as such, only additional fees they have to pay. Within 30 days no additional fees, only normal fees. Beyond 30 days up to 270 days additional fees has to be paid. Then company gave loan to employee for subscription of their own shares. Is it amount to buyback? Now, can a company give loan to employee? Yes, they can give loan to employee. How much loan they can give? They can give loan up to 6 months salary in advance. But they should not give loan to key managerial person, directors, okay, MD and all. Even though MD can be called as an employee, you should not give to employee. Means like a key MD. Now, in this case, the company, if they give loan up to 6 months of the employee's salary in advance, there is no problem. It is not amount to buyback. Next, so with this, we have completed this mock test. This 12 question consists of 60 marks. So around 66 marks I have explained. See, we have used just 12 minutes and we have covered 60 marks. So in exam, when you are going for exam, how to utilize the 15 minutes? So if you see the question paper, you just see from which area it is from. Okay, that's how you should analyze it. First 15 minutes they are giving, no, 1:45 to 2 o'clock they will give the 15 minutes time. We should utilize this time to just analyze, okay, from where this question is from, okay, which point of the chapter it's from. So like that you analyze and it will be easy for you. And to subscribe for more things, so subscribe to YouTube account. You can click subscribe, and you can also WhatsApp me 99405 1288. Thank you so much for seeing this video. All the best for your examination.